Hi and Assalamualaikum. My name is Nur Anissa and the appending. My mention number is 271459. Today I present about the fact of the cases, factual and procedural background. Chester was required to pay Murphy $4,000 per quarter for the first years of the contracts. However, if Chester paid for an entire contract year up front, it was only required to pay $15,000 for the year. Chester, for the second and the third years of the contract provided that the price is subject to adjustment at the ends of each year in which this agreement is in force. The contract further listed the hours and the days during which service would be performed, and it provided that Chester would incur an additional charge for covered work performance outside of the specified day and times. Chester paid $50 upfront for the first years of the contract. July 1st, 2015, Murphy submitted an invoice for the second years of the contract in the amount of $60,371. It made a payment of $168.30, which corresponded to an invoice for work that had been performed on a day or time not covered under the contracts. It voided the third years of the contracts as a matter of equity, and it awarded Murphy. Chester filed a motion for reconsiderations. Billing rate. In its first assignment of error, Chester argues that the trial court added a rate in failing to enforce the clear and unambiguous terms of the contracts to service performance outside the scope of the contracts. Hamilton North C04039339 and C040350 2050 or Ghou 11844. Hamilton number C030019 2003 or Ghou 567021. Chester first arguments that a rate of $19 per hour should govern all charges for work performance outside of the contractually specified dates and time and for work that was not covered under the contract. If you request that the normal and regular examination adjustments and or repair be made at the times others than the regular working hours as set fronts above, then you agree to pay the difference between our regular and overtime billing rate. Carlisle addressed this discrepancy and explains that in 2016, the difference between regular and overtime rates had increased from $19 to $121 per hour. Chester contends that the trial court's rate in awarding Murphy adjustment calculated at a rate of $136 per hour on these two invoices, but the contract language providing the Chester will own the difference between a technician's regular and overtime billing rates for this type of work was clear and unambiguous. The trial court did not err in relying on the Chester's testimony and determined that the difference in rates was $136 per hour in the years 2016, and the Chester was required to pay these two invoices as charged. Murphy has failed to establish that Chester had requested the service charge in the invoice during a time not covered under the contract. He specially stated tea curtaining came in the evenings. At the same point, the trial court did not err in relying on the Carlisle's testimony and awarding Murphy the amount sought for overtime work in this invoice. Damage for years 2 of the contract. Murphy invoiced Chester's $16,371 for the second years of the contracts. The trial court awarded Murphy judgment for this full amount, less Chester $8,500 payment that Carlisle had considered should be applied towards payments of the second year's contract price. Chester argues that because Murphy had stopped performing on the contract in March of 2016, the trial court erred in awarding Murphy the full amounts invoiced for years 2 of the contracts. It contends that Murphy is only entitled to damage on the amounts that is performed service during that contractual years. While we agree with Chester's arguments that the trial courts erred in calculating the damage owed to Murphy for its service under years 2 of the contracts, we disagree with the Chester suggests measure of determines the correct amount of damage. Here, had there been no branch, Murphy would have received the remainder of the amount invoice on years 2 of the contracts, less its expenses. Murphy, therefore, was entitled to damage in the amount of the lost profits that it will have received for the remainders of year 2 of the contracts. We sustain Chester's second assignment of error, and we vacate the portions of the trial court's judgments awarding Murphy full payment on the amounts invoiced for years 2 of the contracts. This causes is remanded for the trial court to calculate the lost profits on the remaining months of the second years of the contracts and to award Murphy damage in that amount.
Issue of the case is first, factual and procedural background. Chester and Murphy entered into the contract for Murphy to perform maintenance service on certain elevators located in a hotel and water park owned by Chester. The contract commenced on August 1st, 2014 and provided that it would continue for a period of 3 years. Then, Chester was required to pay Murphy $4,000 per quarter for the first year of the contract. However, if Chester paid for an entire contract year upfront, it was only required to pay $15,000 for the year. With respect to the price earned by Chester for the second and third year of the contract, the contract provides that the price is subject to adjustment at the end of each year in which this agreement is in force. So the following formula for adjustment will be used: not more than 3% of the current price. The second issue is billing rate. It is a first assignment of error. Chester argued that the trial court erred in failing to enforce that clear and unambiguous term of the contract to service performed outside the scope of the contract. Where a contract terms are clear and unambiguous, interpretation of the contract is a matter of law. So Chester first argued that a rate of $90 per hour should govern all charges for work performed outside of the contractually specific date and times and for work that was not covered under the contract. The third issue is the match for year 2 of the contract. It is second assignment of error. Chester argued that the trial court erred in awarding a judgment compensating full payment under the second year of the contract. Murphy invoiced Chester $63.71 for the second year of the contract.
Assalamualaikum warahmatullahi wabarakatuh. I'm Najah Hizah Zarifah binti Nordin, 272540. The holding of the case. The holding of the case refers to the court in session referring to the previous court rulings that have similar or equal terms in content of justification. In the case of the Murphy Elevator Company, Murphy as plaintiff represented by Christopher R. Hicking Co. LLC and Christopher R. Hicking versus 1130 Chester LLC / Cincinnati Water Park Coco Key Hotel and Water Resort. Chester as defendant represented by Ripper Pagan Law Ltd and Christopher J. Pagan Inc. INC. These court rulings were quoted. They were first, Andrew versus Power Marketing Direct in 2012, Ohio argues that lost profit may be recovered in an action for breach of contract where first, profits were within the contemplation of the party at the time was made. Second, the loss of profit was the probably result of the breach of contract. And three, the profit are too remote of speculative. Para 17 stated, where a contract terms are clear and unambiguous, interpretation of the contract is a matter of law. Second, Ruchi versus Air Pro Inc. First, District Hamilton number C040339 and C04350 2005 Ohio 184 para 4 support the contention that where a contract's terms are clear and unambiguous, interpretation of the contract is a matter of law. In such instances, the court in session conducts a de novo review which does not incline to any previous court ruling of the same nature for its own ruling. Number 3, Kelly Dewatering and Constant CO versus RE Holland Excavating include 1. District Hamilton number C030019-2003 Ohio 5670 para 21 clarifies that a contract will be considered ambiguous where its terms cannot be clearly determined from reading of the entire contract if its terms are susceptible to more than one reasonable interpretation. Number 4, the case of Evans Landscaping include versus, the case of Evans Landscaping Inc. versus Jury First District Hamilton number C090139-2009 Ohio 6645 was in favor of Murphy getting the remainder of the amount invoiced on year 2 of the contract, less its expenses. Murphy was therefore entitled to damages in the amount it would have received for the remainder of the year 2 of the contract.
Hi and Assalamualaikum. My name is Nasaina Batrisha binti Nazri and my matric number is 272700. I will continue our presentation with the rationale of the holding. We agree with the holding made by the court according to Murphy Elevator Company cases. The court allowed the plaintiffs claim for breach of their contract and rejected the argument by the defendant saying it was only responsible for the unpaid money until the time the plaintiff stopped committing. The trial court issued a judgment crediting the defendant for the $8,500 payment and awarding the plaintiff $3,626.40 in damage. The court allowed the plaintiff claim for breach of contract as the trial court found that the parties' contract covered only the days and times specified in the contract and the Murphy submitted invoices were valid. It voided the third year of the contract as a matter of equity and awarded Murphy $22,126.40 in damage. However, the trial court crediting $8,500 payment for Chester toward the amount billed for the second year of the parties' contract. The trial court should not have charged Chester premium rates for the service performed outside the contract. The court rejected the defendant's request for reconsideration for failing to pay the second half of the contract second year because the court determined that the award of damage should have put the aggrieved party in the same situation as if the breach had not occurred. This is because Murphy will collect the remaining amount billed in the second year of the contracts minus its expenses if there is no breach. Therefore, Murphy is entitled to compensation equal to the loss of profit to earn during the second year of the contract. I think that's all for me. Thank you.
In the final analysis, evidence and fact in the issue between Ohio Hamilton Country and Aaron Freeman, there was no breach of contract. The defendant Aaron Freeman's appointed counsel had advised this court that after a thorough review of the record, he can find nothing that will arguably support appellant appeal and that the appeal is wholly frivolous.